My name is Mélanie Jacques. I'm a partner in the litigation group in the Montreal Dentons office. I do mostly constructions, file, insurance, and class action.
And I'm Anthony Franceschini. I'm an associate in the Montreal office in the litigation group. Also construction and class action lawyer, and a lot on the product liability side on that end. And I've also worked on some large arbitration matters, which is part of what we're going to be talking about to you today.
And I've worked on the Lac-Mégantic file. So.
Yes, which will be sort of the underlying factual basis to the presentation. So here's the outline for today's talk.
We'll go through the rules of procedures on discovery, on document discovery under Quebec law and Ontario law. We'll briefly go through the what you should put in your preservation policy. You should transfer your documents to your external console. The database and hosting services, the e-document review and management, and then we'll briefly discuss the Lac-Mégantic file. And we will also go through the Quebec Business Concerns Records Act, which is a little bit weird, you'll see. And we will we'll take your questions if you have some. And you can ask questions during the presentation, so feel free to ask questions.
So rules of procedure. Before we start, e-discovery, for those of you who may not be familiar with the term, is basically the process of identifying, preserving, retrieving, reviewing, and producing documents in the context of litigation. Melanie will go through the various duties under Ontario and the comparison with our Quebec law. The goal today is not to give you, all the rundown on the Ontario best practices. There's extensive documentation on that that's provided by the Ontario Bar Association pursuant to Rule 29.1 of your rules of practice. But we'll be giving you more of our, experience-based, best practices on what should be done to make the process more efficient and timely.
So the main difference between the Ontario law and the Quebec law is that under Ontario law you have to prepare an affidavit listing all documents related to the litigation, and you have to send that affidavit to the opposing party. Under Quebec law, it's a request-based system, so we don't list the documents we have in our file. The opposing party has to ask for them during examination on discovery process. So during the examination, the other party will ask for undertakings, and then the party will have to provide the documents which were asked. So we'll go through the rules. So under Ontario rules, the Rule 30 states that you have to serve on every other party an affidavit of documents disclosing the full extent of your knowledge of the all documents, information you have relevant to the litigation matter. And the consequences related to the failure to do so can be the prohibition to use a document, the dismissal of your claim, the striking of your pleadings, the award of cost. So it's an important thing to do, your affidavit, so you have to be cautious about that. Under Quebec law, and you have to list all documents, and the definition of documents is very, very large, broad. So it can be correspondence, handwritten notes, survey recordings, any recordings you have, videotapes, films, books, photographs, financial statements, faxes, phone conversation notes, So you have to list all of them. As I've said earlier, under Quebec law, as you see, it's a request-based systems. So we ask for documents during examination and discovery process. So as a counsel, during examination, I will ask the opposing party for documents. The opposing party won't tell me what they have in their file, so I have to discover what they have. So I have to ask questions. I can ask for any relevant document. The relevance is defined at Article 286057 of the Civil Code of Quebec, which reads as follows. Evidence of any fact relevant to a dispute is admissible and may be produced by any means. So I can ask for any relevant document in the file. And the Supreme Court of Canada in Glegg versus Smith and Nephew has said that being relevant means being useful for the conduct of an action. So under Quebec law, I can ask for any useful document related to the litigation matter. Also, under Quebec law, at Article 2860 and Article 2862, it's stated that the content of a written document can only be proven by producing the original. So that's why a client has to preserve all the original. It's important. And we will have in Quebec a new code of civil procedure that will enter into force in a month, almost. The new code of civil procedure is there. The objective of the new code of civil procedure is to ensure the accessibility, the quality, and then promptness of justice. And there will be a new article, so it's new law under Quebec law, Article 20. And under Article 20, it's provided that each party has to keep one another informed of relevant facts in order to have fair debate. And each party have to preserve all relevant evidence. So that's new law under Quebec law. We expect that that provision may be interpreted by the judges as you have to do in Ontario law. So we may have in the future to list all documents we have in our file and give that list to the opposing party. So we'll see in 2016 how this provision will be interpreted by the court. So we'll now move to the document preservation policy. So if you do not have actually a general document preservation policy, when do you have to implement one? You have to prepare a document preservation policy as soon as you receive notice of litigation. To who you should send that preservation policy to all person involved in the litigation, all person who have worked with the file, who are related to the file, or if you're in a big company, you can send your document preservation policy to management, and then management will have to inform the employee under their supervision. You have to keep it simple and short. And the first step for you should be to identify one person who will be in charge of that preservation policy. That person should be a senior employee in your company or maybe internal counsel. Now, what do we put in the preservation policy to make sure that you you do what you have to do under Rule 30 of the rule of, I don't know by heart.
Practice.
The rule of practice. So the content of your preservation policy. First, on the top of your preservation policy, you should write that it's privileged and confidential within your company. You should also add a sentence in your preservation policy that this policy and information it contains are strictly confidential. You, in your document preservation policy, you should identify all individuals or persons concerned by the file, so you can list them in your preservation policy. You should describe the nature of the file, so the litigation matter. So we have been sued by X person, and they are claiming for A, B, C, D. So describe the nature of the litigation so your employee will know what they are looking for. Identify also the time frame. So we have been sued by X and X for this matter, and you have to look for documents from 2003 to today. So identify the time frame to help your employees search for the documents. You could also, in your preservation policy, identify the possible locations they have to look for. So computers, whatever place you put your documents in. Please indicate also the consequences for failing to preserve documents. So the consequences may be striking of a defense, pleadings, prohibition to use a document which may be in your favor, award of costs against your company. So make sure you identify the consequences of the failure to preserve the document so your employee will know the importance of preserving documents. You have to write that they have a duty. So each employee, the company have a duty, but each employee have a duty to preserve the documents. You also have to indicate that they will have to preserve it until the end of the litigation matter. Put a description of all documents you are looking for. So you can write, for example, the documents relevant to that matter are likely to include and list the documents you think you're looking for. And please indicate the name of a contact person, so the person in charge of the preservation of documents for that file within your company, so the employee can relate to that person and ask that person questions if they have doubt for a document. So if they don't know if they should preserve a document or not, they will have to ask someone, should I preserve it or not? So that person who will make that decision should be the person in charge of your preservation policy for that file. And don't forget to put in your preservation policy that if the employee, so write it very clear, if you're not sure if you should preserve a document or not, you have to preserve it. So it's better to be on the safe side because of the consequences of failing to preserve documents. You can put additional instruction in your preservation policy if you have additional instruction. Concerning the privilege communication, that decision should be made by your internal counsel or external counsel. So you should ask your employee to provide you with all the documents, and at the end, counsel will make a decision if a document is privileged, and if it is privileged, it won't be listed in your affidavit. So don't ask your employee to make that decision. And you may indicate to your employee that if they need assistance, they can also rely to your IT expert, if you have IT expert within your company, because they may need help to preserve some documents. So they may need help from your IT people. The best practices when you transfer all your information to your external counsel who will read all the documents, you should transfer all your documents in your original electronic format. You have to make sure that you do not modify your document. So you have to preserve the integrity of your document. And you may need assistance from your IT people or external IT experts to make sure that you preserve the integrity of the document when you transfer it. Sometimes you will have a hard time to retrieve attachments which were within the email. So you may also need an IT expert to retrieve those attachments, because you have to make sure that the attachments will follow the email. So involve your IT specialist. Be careful not to access files that are inactive. Don't ask me what is an inactive file. I'm not sure, but your IT people will tell you, because when you access an inactive file, it may change the metadata of the document, and that's a modification of a document, and you cannot modify a document. So when you have an inactive file, you should ask IT expert how to transfer the documents without modifying the document or the file. Make sure that all sources are checked. You may need to translate some documents if it's required. So when you transfer your documents, you may need to translate some of them. When you transfer documents, avoid email. So you should use secure data transfer, such as Acelion, NFTP, Firmex. So you should ask your external counsel what data transfer you should use. Here at Dentons, I know that we use Acelion to transfer documents, so you have to put password and stuff like that, so it's considered secure. So avoid emails.
Now, moving on to database services and hosting services. Once all the documents have been transferred over to external counsel, and again, I think the takeaway from that is let external counsel deal with the details and issues. Your external counsel will be apt to take the decision as to what needs to be done in order for the file to be complete. But once that's done, Dentons has endorsed iPro as a document management platform. And the reason is it's a collaborative platform which allows you to share documents and to review documents even remotely. Some of you may be familiar with older platforms or other software that exists, such as Relativity and Summation. Dentons has migrated towards iPro, which is probably the most user-friendly database out there. and it allows for document tagging, sorting, search, review, annotation directly into the database. So no matter how many users you have, the status of the review is accessible to everyone collaborating on the file. So we wanted to give you a little demo this morning of what it does and the power of the tool, but unfortunately due to technical restrictions, we'll have to work with some screenshots that we've put up for you. So just to give you a little
We know it's small.
yeah, it's very small, but hopefully you can follow on your printouts. This is basically the main screen that you would see in iPro, and as you see, this is what we qualify as the most user-friendly database out there. On the left-hand side completely, you have a list of what would be documents, and of course, this is a test database. So you're looking at a no-name file, but on the left-hand side, you have your list of documents that you can go through. And the way this works is that the iPro database will assign a document number to everything that is put into it. It will also take care of any duplicates or any corrupted files, so it will let you know when you have to adjust or look for original formats or other formats of a file that that is not recognized. The box right next to it on the right is what you would see as what Melanie was referring to, the metadata box. So all the information that's encrypted in a document is going to be surveyed and displayed in that box, along with additional coding that the user or the reviewer can do. So on the right-hand side completely, you have the document viewing page, where the document will show up, and now unfortunately, you don't see a document there, but if you would have an email, for instance, you could scroll into that email, make highlights, make notes, make links to other documents that you may have found that are connected to it, and assign tags. And the tagging system is extremely important because it allows you to segregate documents based on subjects or based on time periods or issues that are related to the litigation. And so those would appear in that column on the right-hand side, just before the document viewing window. The next page is an example of a coding form. So as I was referring to the tags that can be added to documents, you'll see on this page, these are again our sample tags taken from a template case, but you would have review, pleadings, undertakings, expert witness, comprehensive coding, exhibits, and then 910 you have production or privilege. So you can flag privileged documents, you can flag documents that you want to keep for production later on, and all this is preserved continuously in the system. So anyone that uses this is not going to restart from zero, is always going to be building up on what the previous user has done. You also have some analytics tools to determine how many documents you have in total, what percentage of them have been reviewed, what percentage has not been reviewed, and this will also come up when you're reviewing the not reviewed documents. Will have an unread signal next to it, and it's kind of in the same way you work with email. So again, it's a very complex tool, but this is what we call the most user friendly. And your external counsel should be left in charge of that. However, we have seen clients that are mostly larger corporations that have large litigation departments in their legal team that will be equipped with iPro. And in that case, obviously, it makes it easier for external counsel because the document transfer will be made from one iPro database to the other. So, for instance, once the preservation policy or the litigation hold memo is sent, some clients will have already loaded up all their documents in iPro and then just transfer the database to us. So obviously that's ideal, but in any other case, let external counsel do the work and make the decisions regarding to document management. So the goal is always to go from this to this, because when we receive documents, you'll have thousands of documents that are not always in any order. So the use of an iPro database, as we used in the Lac-Mégantic case and other cases, allowed us to, again, perform searches based on issues that we knew were going to be raised in the litigation, and have rebuild the chronology and rebuild all the factual matrix for each of these issues based on what the client provided. So in terms of best practices, again, building an efficient review team is key, both on the external counsel side, but also internally, to have some key people that will know personally, have personal knowledge of the documents, and that can help you help you and external counsel in any event if you have questions on the relevance or the context of a document. And it's important to set privileges. In other words, have people that can only review and people that can actually manage the database to avoid any disasters like the deletion of documents or modification of work that has been done previously. Identify the issues, like I mentioned. It will help you tag and better segregate documents based on their relevance. The people that should be assigned these tasks need to understand the litigation globally to have a better understanding of what we're looking for. The tags, although they're very useful, having too many of those could become counterproductive, so it's important to review internally and with external counsel what the essential steps in document review need to be and at what time these need to be undertaken. So based on time periods, based on relevance, and on which individuals are connected to these documents, especially if you're doing a document review in preparation for examinations. Identify who is being examined, because this will all help in order to build an efficient tagging system of these documents. And of course, like any project, set schedules, set deadlines, and make sure that you have a project manager of the document review system. And of course, involving the internal legal team may be very useful in the sense that they are the custodians, or the custodians are within the organization and can assist in developing a strategy for that. So the bottom line basically on our e-document review and management processes: do not overlook or do not underestimate the value in putting all these steps in at the outset of a litigation. It may come with a cost association, but the cost that you will incur at the outset will definitely outweigh the absence of such a system or such a document review policy put into place. We've experienced it, like I said, in the Lac-Mégantic file, but other large arbitrations. And when you're dealing with 50, 60, or 100,000 documents that may be produced at any given time, it helps to have a structure that's in place from the beginning so that everyone knows what the expectations are. Also, when you're moving in the context of, especially in Ontario, of e-discovery with set guidelines, it's expected that opposing counsel would, in any event, make these requests. So to align and to discuss these issues with opposing counsel from the beginning allows to save costs and make the process more efficient by the time we get to the production stage. So Lac-Mégantic.
So in the, my turn. In the Lac-Mégantic file, I don't know if you recall that accident. It's the worst train, non-passenger train accident in Canadian history. The train was in MMA train, so Montreal, Maine and Atlantic Company. Train 74 cars train rolled down from Nantes, which is a city 11 kilometers from Lac-Mégantic. So the train rolled down from Nantes to Lac-Mégantic and exploded in downtown Lac-Mégantic. It destroyed I don't know how many buildings. I think it's 30 buildings in the downtown Lac-Mégantic. It exploded on July 6, 2013, just after midnight. Killed almost 50 people. So it destroyed all decor downtown. So as I said, it's the worst train accident in Canadian history. So a month after the accident, as expected, someone filed a class action before the Superior Court of Quebec. 50 defendants were listed in the class action. 30 law firms represented those 50 defendants. Dentons represented the directors and officers of MMA, and also holding companies related to MMA. On August 8th, 2013, there was an initial CCAA order that was issued. So it's an order under the Company Creditors Arrangement Act. A stay of proceedings was granted to prevent multiplicity of action against some defendants. So a stay of proceedings was granted for some directors and officers and some employees of MMA, the actual company, MMA, and the insurance company of MMA. The insurance company was Excel Insurance in that file. So Excel got a stay of proceedings. There was a 25 million insurance coverage for MMA, which was not enough to cover all the damages caused by the train accident. Just for the claim for the cleaning of the city of Lac-Mégantic exceeded, I think it's $400 million. So the insurance coverage was not enough. There was a cross-border insolvency protocol put in place because there was a Canadian company, which was MMA company, and there was also a US-based company, which was MMA Railway Company. So the mother of the Canadian company was in the US. So that's why there was a cross-border insolvency protocol. So both insolvency proceedings were following the same path at the same time. And there also were parallel criminal proceedings against 3 or 4 MMA employees. The train driver and the dispatcher and the supervisor of the dispatcher, because it was alleged that the train driver didn't put enough brakes on the train, so that's why the train rolled down to Lac-Mégantic. So as I've said, Dentons represented DNO of MMA and holding companies. The litigation team for the DNO included 9 lawyers. We were 4 in Montreal, myself, Anthony, Laurent Namiache, and Roger Simard, which is an insolvency partner lawyer in Montreal. 5 lawyers in Chicago were also included in the team. They were responsible for the US proceedings, and we were responsible for the Canadian proceedings. So the class action, the insolvency proceedings. We didn't represented the employee in the criminal proceedings. The class action against our clients alleged the poor safety culture of the company, poor safety stats, policies, lack of staff training. So we were looking for documents which detail the training given to the employee, the stats relating to safety. I think a month after the accident, thousands of documents were seized by the Sûreté du Québec, which we received a copy of.
And that's our provincial police, the equivalent of the OPP, basically.
Yes. So we received 1,000 documents seized by the Sûreté du Québec, and the Sûreté du Québec also seized I don't know how many computers in the MMA company. So we had all the information contained in the computers. So we had to put that in something to be able to review all the documents of our clients. So that's when we didn't use iPro for that file. We use Relativity. It's a Commonwealth database. We didn't use iPro because our U.S. Chicago office is using Relativity, so we had to find something that we were both using, that we would be able to use on both sides. And we also had to make sure that we kept the document that came from the U.S. side apart from the documents that came from the Canadian side.
And vice versa.
Yes. And Anthony will explain why we had to do that.
And the reason for that is that we realized that there was a Quebec blocking statute that would essentially that created an exception for documents concerning a business to be transferred over to the U.S. side. And so this may come as a surprise this morning, but we have a Business Concerns Records Act in Quebec. And what may come as a further surprise is that Ontario has the same exact piece of legislation. However, these statutes have very rarely been used, and they essentially block any document concerning a business in Quebec or Ontario to be carried over or sent over in a foreign jurisdiction. Now, business concern is a terrible expression for a business being carried in Quebec. But as you can see from the definition of document, it really includes any writing, every form, any report, any statement concerning a business. So, for instance, in the context of a subpoena being issued by a foreign jurisdiction, this statute could be invoked, and it has not been so very often, simply because lawyers just don't know about the statute. But we had previous experience with the statute, and I'll get to the precedent a little later on. But I've put up on the slides basically what the blocking provision is, and it says no person shall, under requirement from a foreign jurisdiction, from any place in Quebec to a place outside of Quebec, transfer a document concerning a business. Now, that does include other provinces, but you'll see that in the Hunt case from the Supreme Court in 1993, the Supreme Court invalidated the statute as regards interprovincial collaboration or interprovincial litigation. And unfortunately, the Supreme Court did not go as far as to invalidate the statutes with regard to foreign jurisdiction, but there is an interesting passage at page 327 that says, everybody realizes that the whole point of blocking statutes is not to keep documents in the province, but rather to prevent compliance and so the success of litigation outside the province that the province finds objectionable. This is no doubt part of a sovereign right, but it certainly runs counter to comedy. And later on says it discourages international commerce and efficient allocation and conduct of litigation. Now, there has not been any challenge of this statute on an international, in an international context, both the Quebec and the Ontario equivalent. There's very limited case law on this issue. In Ontario, we found 3 cases that dealt with the Business Records Protection Act, and only one case was the person being requested the document successful in invoking the Business Records Act of Ontario. But what's funny is that case was actually rendered by the Quebec courts. So the Quebec courts were asked to apply the Ontario statute, and they applied it, and it was confirmed by the Court of Appeal. However, this was before the Hunt case. So as of today, the state of law is that between Canadian provinces, these statutes cannot be invoked, and only Ontario and Quebec have these blocking statutes. On the international scene, however, it remains unclear what the relevance of such a statute is. Our view is obviously that with regards to international comedy, this type of statute should not be applied. Unfortunately, in 2013, the Quebec Superior Court, in a case I was personally involved in, reaffirmed the relevance of this statute even in 2013. And this was in the context of patent litigation in the US, where we were representing Acre Biomarine. They were being sued by Neptune Technologies in the US before the International Trade Commission for patent infringement. And Acre, as part of their defense, wanted to depose and obtain documents from individuals that worked on the invention in Quebec, namely someone at the University of Sherbrooke and another individual, a scientist from the, I forget the exact name, but a science institute that's funded by our government, our provincial government. And so the ITC issued a recommendation, which was then endorsed by the U.S. District Court, and basically a formal letter of request was sent, was drafted and issued by the U.S. District Court, which we then presented to the Superior Court of Quebec. And Justice Castonguay, in that very interesting hearing, rendered judgment which essentially blocked the disclosure of documents and prohibited the evidence to be obtained from the Quebec individuals, stating that the request from the U.S. District Court was a fishing expedition. So in other words, it was too broad under the requirements of our Quebec Civil Code of Procedure, which is a little strange because that's applying our rules of evidence to a U.S. case. But second of all, the judge did state that the documents were protected by the blocking statute, and this is what our counterparts were arguing. And although we argued the Hunt case and explained that it was probably inappropriate in such a context, the court did maintain the decision. So this all begs the question, should foreign jurisdictions reciprocate when requests come from the Quebec courts? I think it's very interesting. Just to give you the state on this, there is no plan to repeal the act, although the Quebec Bar Association has made a formal request to the Quebec General Assembly, Provincial Assembly to work on a repeal. So more to come on that.
So that's why under the Lac-Mégantic file, we had to make sure that every document that was seized in Quebec stayed in Quebec, and that we had to make sure that the U.S. counsel in our Chicago office could not access that document because it would be a breach of the Business Record Act.
Or potential breach.
Potential breach.
So
even if it's the same company, same client.
But it wasn't in some
sense. It's a different company, but...
And there were individuals and companies being sued, so we just took we took an approach that was more on the safe side on that one. So that wraps it up for us. If you have any questions, either in the room or online, I think we have a couple minutes. Yes?
The blocking statute is invoked by the people who are having the record request.
That's right. So if you receive a subpoena in Quebec for documents that are requested in a litigation taking place outside of Quebec, you may invoke the statute. And as I said, it's been invoked successfully, very recently. Yes?
So the services like iPro and the other ones you mentioned, are they generally charged as a disbursement on external counsel's account, or how do you deal with that?
Yeah, it is. The access to the database and is going to be charged at the disbursement. Now, it will depend on how the case is. On how this software is normally used with that client. In other words, if we have a repeated use of this software, because you're paying for users, you're paying for usernames and access codes. So if the client has repeated need for it, then we may include it in our fees. Obviously, this can all be part of our AFA policies, but if it's for a one-time thing, it will probably be charged as a disbursement, and that's what we did in the Lac-Mégantic case. We charged, as part of our disbursements, the access and the hosting services of the platform. But as I said, it can be arranged to be part of the continuous ongoing fee structure.
Generally, the time for putting in the documents and organizing, is that done by something like iPro, or do the lawyers do that?
We have our IT and paralegal staff that will take care of that, because they have the the technical knowledge to do it, and again, the time put in is of course is an upfront investment, but our experience is that on the long run, especially in litigation that drags on for months or years, our experience is that that investment is definitely worth, the upfront money.
It's so easy when you're asked to provide a document relating to contract A. You just go in iPro and type contract A, and then you have like 20 documents, and you know that you have everything. You don't have to go through and read again everything and try to find it in your file. So it's worth it.
And clients can be connected to the database, as I briefly mentioned, because it's all remotely accessible. We can give accesses to the clients to either review or just to, to view the document. So it allows a very efficient collaborative synergy between the client and external counsel. Any other questions? So I guess all we have to do is to remind you that there's lunch being served. And don't forget to fill up your feedback forms. And if you came in after we started, sign in.
Sign the.
So you can get your credits.
Yes.
Thank you, and enjoy the rest of your day.